being here. My name is Gabby Smith. I'm one of the co-presidents of the Plaintiffs Law Association. I'd like to introduce our speaker and moderator today. Nora Freeman Engstrom is the Ernest W. McFarland Professor of Law at Stanford Law School. She is a co-director of the Deborah L. Center on the Legal Profession. Professor Engstrom is a nationally recognized expert in tort law and legal ethics. She was the 2025 recipient of the William L. Prosser Award, a Lifetime Achievement Award for her contributions to tort law. She is also a Stanford Law graduate, class of 2002. Shanin Specter is a founding partner of Shanin Specter, one of the leading catastrophic injury firms in the U.S. As a trial attorney, he has achieved 16 8- or 9-figure jury verdicts involving medical malpractice, premises liability, defective products, and general negligence. Mr. Specter is a member of the Inner Circle of Advocates, a group of the best 100 trial lawyers in the country. Beyond his accomplishments as a trial attorney, Mr. Specter is a lecturer at Stanford Law School, teaching how to ask a question in the recent Trial Lawyer Skills Workshop. Thank you.
All right, Shanin, I am so happy to be chatting with you. This is the first time we've ever done this. And Shanin and I have known each other for more than a decade. And as Gabby suggested in her intro, Shanin is widely regarded as one of easily the top 5 and maybe the top 2 or 3 trial lawyers in the United States. So it is such an honor to be chatting with you. And I would also say is one of the lawyers I most admire personally. David and I have jokes about who we would call, like, if the really bad thing ever happened. And you are certainly on both of our speed dial, although hopefully we will not be doing that. But as Gabby suggested, you've tried a lot of cases. You've been trying cases for decades. How has your approach to trying cases changed over time?
Well, first of all, thanks, Nora, for doing this. And I love being at Stanford Law School for absolutely any purpose, for teaching how to ask a question, which I'd like to promote, if I may, to those of you who have not taken the class. It's in the winter quarter. It's probably the easiest one credit course offered at the law school, if that's an incentive. And it's a lot of fun. To answer your question, Nora, about how trials have changed, at least from my perspective, since I started practicing law, I don't think they've changed a whole lot.
Yeah.
I would like to think that I approach trials the same way that I always did, which is to understand the case as well as I possibly can, to read everything myself, to prepare witness outlines myself, to prepare my opening statement myself, my closing speech myself, and make all my own mistakes. I make lots of mistakes, but I like to not repeat other people's mistakes, and to do my best, and recognize that a verdict, good or bad, is not a verdict on me. I don't control the facts, and all I can do is my very best in trying a civil action. So I'd like to tell you that things have really changed, and I know there's a feeling that attention spans are less than they used to be. That may be true. I know there's a feeling that people learn through visual aids, video and the like, PowerPoint and the like. I think that is true. I think it was always true. We have more ways of providing visual aids to jurors now than we had when I came to the bar. Back in those days, we used big poster board with our exhibits. And now we rig the courtroom with screens. If it's not already rigged by the court system, then we put the exhibits up on screens. But I don't think the fundamentals have changed.
Can you tell us a couple of your favorite trial moments that you've had over the years?
Well, I think I knew I was going to be asked that question, so I thought about it a little bit. And I was thinking about a case I tried many years ago when I was closer to your age than to my current age. And it was a medical malpractice case in a very conservative venue in Pennsylvania. And I inherited the case from a lawyer who had left the law firm, and the case was something I never would have accepted had it been my judgment whether to accept it. And there was an expert report in the file, and what that means for us as a lawyer, that means that we can, quote, get to the jury, we can establish our elements of proof, and therefore I couldn't get rid of the case. And the defendant physician would not pay any money, so I had to go try the case. And the case involved a very minor injury, if I may be so as indelicate as to tell you that while you're eating lunch. The allegation was that there had been a hemorrhoidectomy that had been performed incorrectly and that the gentleman still had pain. That was the case.
That is not a catastrophic injury case.
It's not a catastrophic injury case. It's not a case that we lawyers economically can accept. And the client was not great. I'll put it that way. He was not great. And I guess the only good thing about the case was the defendant was not great either. And I tried the case. I felt I did a good job, as hard as, I did as well as I could. We prevailed. We got a verdict of $38,000 in this medical malpractice case. And as Nora knows, because she studied the economics of the trial practice very carefully, and as you might intuit, that's not a case which is a financial success. But I was and am so proud of that verdict. That verdict was so hard to obtain because it was a conservative jurisdiction, it was a small injury, I had a client that did not come across well. I had to win the case by essentially causing the jury to think that the defendant was worse than the plaintiff. It was a close call. And as I was leaving the courthouse, I was going down the elevator, and there were jurors in the elevator, and I have a rule about not talking to jurors when my client wins, because I do not want to be told anything by a juror that I have to report to the court, which could then undo my verdict. Oh. So I just have a rule, I don't talk to jurors. But when the verdict was $38,000, I didn't mind. So I said, thank you for your verdict. May I ask how you came to the number? And they said, yeah, we couldn't decide. And we took out 12 slips of paper and wrote down numbers and added them together and divided by 12. That's called a quotient verdict for those who were interested in the evidence portion of that. It is taught in evidence as to whether that's an appropriate way of proceeding. And it's not in some states, but that's what they did. And I said, well, what was the highest amount on the slips? And they said $100,000. And I said, well, how many of those were there? There were two for $100,000. I said, well, if you had two for $100,000, I was just doing a little quick math, then how could the verdict have only been $38,000? And the juror said to me, well, there were a couple of zeros. Okay, I think we should feel, if we're the plaintiff's lawyer there, we should feel good about that case. And I feel my job is mostly to win the liability case. There's not much I can do about damages, right? Either the damages are substantial or they're not. Either the jury thinks that the plaintiff ought to receive a large damage award or they don't. And that perspective, recognizing, trying to be modest about our role as lawyers, I think makes it easier to be a trial lawyer. If we recognize that we're not all powerful, we can't make chicken salad out of you know what, and that helps me.
Mm-hmm. You kind of opened the door here on damages, and so I want to ask, you do have ways to portray the seriousness and the severity of damages to jurors when you have a client who has been seriously injured, probably not a hemorrhoid problem.
Yeah.
What are some things you do and that you think are valuable and powerful to try? I mean, one of the things we talk about in tort law a lot is you have to do this, which is this kind of alchemy of this terrible injury into dollars, and how are you going to do that translation, and how are you going to make that translation sensible and to feel kind of even ethical or moral? So how do you think about that?
There's a lot in your question, Nora, and if you think about tort claims and you divide them into economic damages and non-economic damages, and then you think about there may be a loss of earnings or earning capacity claim, there may be a claim for past medical expenses and personal care expenses, future medical and personal care expenses. Those can be specified, and here again, I think it's important that we not oversell our cases. The damages are what they are, and try to avoid making more of them than what you believe a jury might reasonably believe, because it's going to undercut your credibility on everything else, including the liability part of the case. With respect to non-economic damages, I think you have to do it through a good direct examination of the plaintiff and the family and others who may be involved in understanding the non-economic damages, pain and suffering, loss of life's pleasures, and the like. I think it's important here on those direct examinations for us to stay out of the way. We're not the hero of the directs. The witnesses are the heroes of the directs. Ask short questions. Ask them in a way which is non-dramatic. Let the focus be on the witness. Position yourself physically so that you're standing next to the witness box so that the jury can see the full face of the witness and not in profile. Try to get away from the center of the courtroom. There are a lot of courtrooms, especially in federal courthouses, where the judge wants you to be over in the center of the room, and now the witness is in profile. And that's not great, especially when it comes to things like damages, where a witness may be emotional, and you want the jury to be able to see the emotions of the witness and be able to judge in a very, very direct way the witness's demeanor. So there's that part of it. Then there is the advocacy part through the statements and even through voir dire. You have to do your best to prevent prospective jurors from getting on the jury who cannot be fair in making damage awards. And there are a series of questions. It's beyond the scope of this talk to get into what questions those would be. Happy to provide you with that information if you'd like separately. But you have to try to weed out bad jurors in voir dire. In the opening statement, again, I think you want to undersell. They don't know you that well. Let the witnesses carry the damages in the bulk of the case. When it comes to the closing, I think that it's important that we elevate our closings as best we can. How do you elevate your closing? Well, one way that I've used repetitively, I think to good success, is to use poetry. There are some wonderful poems about suffering, and that can be very useful. One poem that I've used repetitively is Dirge Without Music by Edna St. Vincent Millay. I confess to changing the words slightly. I also tell the jury I change the words slightly when I do that, because I'm always concerned there might be a juror that knows Dirge Without Music. And if I'm in a jurisdiction where I can argue lump sum damages or per diem damages, of course I will do that. Most of my cases are tried in Pennsylvania, where we cannot argue either for lump sum or per diem damages. We're one of only 4 states that have that rule. And I tried a case in Chicago in November of last year. I'm going back in a couple of weeks to try another case in Chicago, same common corpus of facts. In Illinois, you may seek both per diem and lump sum damages. And wow, that's really great. You can make the Michelangelo speech. For those of you who don't know what the Michelangelo speech is, imagine that the decedent is living, had not died, had not been malpracticed upon or the victim of a defective product, imagine that they're in the building across the street and they could be saved. And in the same building, in the same space, there's a Michelangelo, which is worth, you pick the number, right? You have to decide, what will not make you blush, because you have to not blush when you start talking about numbers. But let's say you were to say $100 million. The Michelangelo's worth $100 million, and you can only save one. The building is on fire, and you can only save the decedent who's come back to life or the Michelangelo. It's up to you. Who are you going to save? The answer is obvious. It's not a close call. So the damages in this case obviously are very, very substantial. You don't have to actually spell out the punchline part of it. It's apparent, right? I can't do that in Pennsylvania, but I can in Illinois, and so of course I do.
Yeah. Y'all are probably thinking back to Suffert from torts class, which is about per diem damages, in part. You just said you're going to trial in Chicago in a couple weeks.
Yes.
What kind of trial are you doing in Chicago?
So you all probably remember the Boeing MAX 8 problem, and those planes were taken out of the skies for almost 2 years after 2 crashes, one in the South Pacific and one in Ethiopia. And our firm has represented the estates of 3 of the passengers on the Ethiopian Airlines 302 flight in March of 2019. The case we tried in November of last year was for one of those families, and the case we're going to try in May of this year is for another one of those families. May I say something that's disappointed me about that litigation is that there were 157 deaths, and when that case came up for trial in November of last year, 146 cases had been resolved, all of them through settlement, none through trials. And I felt that it was a disservice by the lawyers involved in that litigation to have not gotten at least one case in front of a jury for a jury determination. I would put myself in that category because I had settled one case. I had a total of 3. And I felt the litigation should not end with at least one case being tried. In your textbook, which of course I use, and I teach secret, by the way, you tell us that, and this is the common view, that the main purposes of the tort system are to compensate and to deter wrongdoing. But there's another important function of the tort system, which is the public information function of tort. I think I learned that most distinctly by reading a piece in Harper's Magazine written by Ralph Nader in 2016, which is really, really good. Anybody studying for a torts exam should just start by reading that article, because it's really the history of the tort system in the United States. And he articulates a third important function of the tort system, which is the public information function of tort. People in the United States, in fact all across the world, should know about the Boeing MAX 8. They should know about the fact of this accident, how many people died, and what was involved in those deaths, how they died, frankly, and what their deaths have meant to their families. So I'm looking forward, I'm glad I tried that case last November, and I'm looking forward to trying this case. And I think it's important that these kinds of things have a public hearing.
I love that you're talking about the information forcing function of tort law, in part because I gave 2 speeches in Denver yesterday about the information forcing function of tort law and just how important it is. I I agree. I think that there are various ways that tort law promotes safety that are not just the law and economic story of cost-justified precautions, and it's really important to have a more expanded and I think more accurate frame. One of the things that's tricky about the Boeing cases is that Boeing has conceded liability. It's quite rare that a defendant concedes liability. It's quite rare that a defendant concedes liability for causing many, 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 many deaths, as it is done here. How will you approach this case differently given that concession? Does that concession, do you see it as a benefit, or do you see it as something that really kind of limits you? The other funky thing about Boeing cases is punitive damages, right? You would think would be very much on the table for the Boeing case, for example, and what we're talking about right now is the second crash. So first a plane crashes, Boeing recognizes the problem in the plane. They keep the planes in the air, and then there's the second crash of a plane that was taking off in Ethiopia and bound for Kenya. But when it comes to punitive damages, you tend to look at where the defendant acted. And here we have a defendant that's headquartered in Chicago and that made planes in Washington. Washington doesn't allow punitive damages at all. Chicago doesn't allow punitive damages in wrongful death cases. For this crash, they've actually recently changed that. How does this kind of strange composition affect your view of the trial?
Well, may I say first that Boeing was very smart to admit liability, and it would not be helpful for them to have the jury hear about the defects in the planes and what Nora just explained to you, which is that there had been a crash 6 months earlier, and Boeing knew exactly what the problem was. They knew they should ground all the planes, and they didn't do so. That caused them later and collaterally to admit to a crime with respect to their conduct. But they have successfully sanitized the case by admitting liability. And we're not allowed to talk about why the plane crashed. We're allowed to talk about what the decedents experienced during the ill-fated flight, with 6 minutes in the air, the pitching up and down, and the ultimate nosedive toward Earth, and what we would expect the occupants experience with respect to pre-impact fright and the like. But I would much prefer to be able to talk about, in addition, the defects in the planes, their criminal behavior, their reckless behavior, not taking the planes out of the air. But I'm not allowed to do that. I would say to you, some of you will be defense lawyers, which is fine. Might not be my first choice, but people need good lawyers, whether they're plaintiffs or defendants. And I think you can learn a lesson if you end up being a defense lawyer from what Boeing has done here. And that is the importance for you as a lawyer to talk to your client about limiting the issues that are going to be tried in their cases and having the courage in the right case to admitting liability. Very few defendants have the smarts and the courage to admit liability and take those issues off the table. And that's true whether it's a motor vehicle accident case or a medical malpractice case, defective product case, premises liability case. Very few defendants are smart enough to do that in these types of cases. So I do believe it is more challenging for me to obtain the type of verdict that I think these cases should bring. And there's something else too, and I think we have to be honest with each other about the limitations of the tort system. We cannot bring a person back to life through a verdict. And money damages are an inadequate substitute for life or health. I think we all know that. And so it takes something, it takes a bit of a leap of faith for the jury to be able to translate the presentation of evidence into a dollar amount on a verdict slip without at least hesitating over whether any of this makes good sense. And I say to the jury, I'm very, I think, upfront about this. I don't want to hide the ball on this issue. I say to them, look, we'd all like to be able to bring these folks back to life. We can't do that. The tort system is limited. All we can do is award an amount of money that is sufficient under these circumstances. But then I explain the principle, which is to make the person whole. In this case, make the family whole. And to use money as a substitute for life or health, even though we recognize that it's inadequate. And I think if the jury can be satisfied that they can speak through their dollar amount verdict for the enormity of what has occurred, then I'm pretty far down the road of obtaining a satisfactory verdict.
So you were talking about kind of your disappointment that more of these cases have not been tried. But of course, there's this difficulty, which is to say the client controls settlement decisions, right? And the lawyer only gets to say so much, but ultimately, as anyone who has taken ethics with me knows very well, it is Rule 1.2a, it is the client's call. How do you, when you feel strongly, as you do in the Boeing case or in other cases where you really feel like, the public needs to hear this, and maybe too where there have been sealing orders in a case and not enough has come out in your view to the point of trial. How do you kind of navigate that difficult ethical terrain where it's the client's call, but you feel really strongly about the case, that the case really should go to trial?
You tell the client exactly what the stakes are, and you explain that while the jury will only be articulating a money damage amount if we are successful, that there is also a great value to you, I explain, to you, and to others for the jury's intonation of the verdict. You will never forget the moment that the jury intoned the verdict in your case, and it will be meaningful for you for the rest of your life. And if you settle your case, you don't get that. And if the case has a public dimension, such as the case we're discussing with Boeing, that also can be discussed, and that is that it's important for people to know what happened. And again, if we settle this case, there won't be a story that'll flash all around the country or maybe even all around the world about the verdict in this case, and that will have an important value in telling the public about what happened and also reminding the employees of Boeing about the harm that came from their misconduct. So it serves many important functions. I have not had a problem in my career in gently prodding my clients in the right direction on settlement. And that could be, any way. It could be trying to get a case into a courtroom, as we're discussing here, or accepting a reasonable settlement in a case that doesn't cry out for a public trial. A typical, let's say, red light, green light case, there's no overwhelming public issue in a red light, green light case. And if the amount that's been offered is fair, or maybe even more than fair, I think we have to talk to the client about those realities. And sometimes clients will say, I want my case tried. Okay, fine, we'll try your case, but I want you to know that it's likely the jury is going to award less than what's being offered. And then it's the client's call. I have found in my practice that clients defer to my judgment because they think correctly that this is my job and that I have more experience than they do and that I have their interests at heart. And after all, we are partners in the case. They are the majority partner. They're the 2/3 partner. I'm the 1/3 partner. Or it could be some other number, right? But I have the same economic interests that they have. That's the beauty of our fee system. And so I just had not had a hard time over the years. It's only been a few times where a client and I have had a disagreement about whether we think a case should go to trial. And it could be either way. And usually we get very easily to a meeting of the minds.
In addition to suing Boeing right now, you're also suing President Trump. And can you tell us a little bit about that litigation?
Yeah. You may remember the debate between then ex-President Trump and then Vice President Kamala Harris in September of 2024 that occurred in Philadelphia. It was their one debate. It was at the Constitution Center. And in that debate, the topic of the Central Park Five came up. The Central Park Five refers to 5 then young men, teenagers, who were accused of raping a woman in Central Park in the late 1980s. And they had, when they were arrested, they had made incriminating statements under coercion, which they promptly recanted. They were tried, they were convicted, they were imprisoned, and eventually the actual assailant confessed, and his DNA was matched to the physical evidence, and he was tried and convicted. And the so-called Central Park Five were freed. They became then known as the Exonerated Five. Some people call them one thing or the other. And they are conclusively not guilty of that crime. Then private citizen Donald Trump in the late 80s, when this incident occurred, had taken out a full page ad in the New York Times calling for capital punishment for the crime of rape. The connection between that prosecution and his ad was clear, and he had spoken about this matter many times, even after their exoneration, and expressing views with respect to his continuing view that they were guilty of that for which they were charged. And in the debate when the issue came up, he said that they pled guilty and they ultimately killed this woman. And the victim of that horrible crime was not caused to die, and she, in fact, is living presently. And the Central Park Five did not plead guilty. So we filed a defamation action on behalf of the Central Park Five in federal court in Philadelphia, and the case is winding its way through the court system. One interesting aspect, may I say, about the case, for you folks interested in civil procedure and also the role of the president in our society, President Trump did not move to stay the case during the pendency of his presidency. And I confess that surprised me a bit, that he didn't do that. There is a Supreme Court case on point called Clinton versus Jones, where President Clinton sought to stay the litigation against him brought by Paula Jones, and he was unsuccessful. And there was a Stevens opinion from the mid-90s saying, in the 200 and some odd years of our republic, presidents haven't really been sued civilly, and we don't see any particular reason to stay a civil case involving a president. We don't see a repetition issue here to be concerned about. Wow, was he wrong? And I think the Supreme Court would be likely to reverse themselves on this issue if the case came back in front of them. And
I also think that opinion says that a civil litigation won't be too distracting. And of course, in the Clinton case, it led to an impeachment. So it's like, well, y'all maybe rethink that.
Yeah, right. The decision was wrong when it was made, and it's even more wrong today. But President Trump didn't seek to take advantage of what I think is the better rule. And may I say, as a citizen, I don't want my president to be distracted by defending civil litigation, even though I'm a civil litigator. But he didn't do that. And I think the reason is because President Trump is definitely the #1 defamation plaintiff in America today. And he's the most successful defamation plaintiff maybe in American history. I mean, case after case, and why he's gotten these favorable outcomes we could talk about, but he certainly has been a very successful defamation plaintiff. And I think he and his lawyers recognize he can't be both an active defamation plaintiff, yet not a defamation defendant. So he is prepared to accept being a defamation defendant so he can continue to be a defamation plaintiff. Kind of remarkable that he is so, by his practice, not his rhetoric, but his practice, so avowedly pro-plaintiff litigation.
Yeah. So where does that case stand now then?
Well, the case got waylaid a bit because we have an anti-SLAPP statute in Pennsylvania. Those things are a horrific albatross that should be gotten rid of everywhere across the country, starting in California. I think this is where it all started. And under the anti-SLAPP statute...
Well, explain what an anti-SLAPP statute is.
Okay, yes. So as if it weren't difficult enough to bring a defamation claim in the United States with Times v. Sullivan and Gertz and all the protections that speakers have in the United States, there's also a rule now in more than half the states by statute that if a defamation matter involves a matter of public concern, and that's interpreted broadly, and the plaintiff is unsuccessful in their defamation suit, they have to pay the defamation defendant's legal bill. It's a one-way loser pays system. If the plaintiff wins, they don't get their legal bills from the defendant, but if the plaintiff loses, the defendant gets their bills paid by the plaintiff. Ouch. That's really, really bad. It's such a bad rule. And among the stuff embedded in these statutes is a provision that if there's a motion to dismiss and it's denied, there's an automatic right of appeal, which we see in a very small number of other areas in the tort practice. We see it in civil rights cases on qualified immunity. But almost always we regard the denial of a motion to dismiss as interlocutorily non-appealable. That can only be appealed at the end of the case. I'm seeing nods, yay. Your husband would be very happy to see that since he teaches federal courts. I think he probably teaches something around that. So there was a motion to dismiss. It was essentially denied. There was a little bit of one aspect where there was repleading suggested, which we repled. That's been appealed to the Third Circuit. We say it shouldn't be heard for a variety of reasons I'm not going to bore you with, but our procedural objection to the appeal is tied up with the substantive appeal, and we're slowed down by this. And that really sucks. May I just say, particularly in the defamation context, I mean, think about defamation, right? Your reputation, you have alleged, has been harmed. It needs to be addressed as soon as possible. We're not talking about a broken leg, which has been repaired, and you can wait to get your compensation. If you've been defamed, you need to have that corrected as soon as possible.
Called a murderer when you're wholly innocent.
It's really a problem, and so that's unsatisfactory. But may I say, before the case was stayed, the president's lawyers were already talking to me about deposing him. I mean, they were not looking to stand in the way of that, which I thought was remarkable. But now that's all been pushed aside because there's going to be an adjudication of the correctness of the denial of the motion to dismiss.
So you love being a plaintiff's lawyer.
And a teacher.
And a teacher. Why?
Well, I'll answer your question.
Okay.
It'll be easier. I love being a plaintiff's lawyer because every case is different. You know, we get to learn so many things about so many areas of life, products, and medical care and motor vehicles and premises and the like. And it's always an educational matter for us. I like being able to help people. Our cases, even the fellow who complained about his hemorrhoidectomy, I like to be able to help people and permit them to have their case heard or adjudicated otherwise. I love the economic aspect of it. I never present a bill to a client. I've never had an argument with a client over what I've charged them. I mean, that's the contingent fee. Their legal bill comes out of the recovery. They never have to write a check for any purpose to me. That's very nice. One of the things about the practice of law is that if you're a defense lawyer or not in the tort system and you're billing by the hour, you get a lot of complaints about your bills. And that's annoying. And you don't have that in the plaintiff's practice. We also don't keep time records in most of our cases. And again, one of the scourges of being a lawyer, one of the things that lawyers complain about is timesheets. We don't have timesheets. So that's very nice. What else I like about the litigation that I'm involved in is the opportunity to enhance the safety of our community. Every case that I have, every single one, I look at and say to myself, is this a case where we should make a demand on the defendant to change their behavior as a condition of settlement? It's not hard for me to convince the client to condition settlement on the defendant changing their behavior. That could be maybe there's a hospital policy that's incorrect, or a school district that's doing the wrong thing, or a police department, or a product manufacturer, and where it's clear, where it's systemic, where it's repetitive. And you as a lawyer can go to the defendant, if you have client authority, and say, we're not going to settle the case with you unless you change your practices, unless you fix your product, unless you fix your policies, whatever it might be. We've done that many, many times in our firm. There are other plaintiffs' lawyers who are also focused on that. I think this is an area of research interest to you, Nora, and to others here at the law school. I'm so glad that you have looked at this carefully. I think it's something that we lawyers should be thinking about in all of our cases. And I feel great about being able to effectuate an equitable remedy, informally it is, because of course we can't sue for these remedies. We can't sue to make a hospital change its policies, but we can say to the hospital, we're not going to settle the case unless you change your policies. And they don't want to try a lot of those cases, so we're able to get these things done. They also say most defendants want to safely operate. So it's not a problem to raise this issue with an opposing attorney. They are receptive to the conversation. And so in every way imaginable, it is something that's practically suitable for accomplishing in litigation. And then for we as lawyers, it's the best thing ever. Because now we're doing something beyond making money, right? It helps us feel good, correctly good, about our role in society. It's something we can talk about in the community. It's something we can put on our Instagram and our LinkedIn and otherwise. We can brag about it. And that's good. It's a way for us to raise the public image of our profession. I mean, we're down there with members of Congress, aren't we? And I think I understand why, right? I mean, just you look at the billboards and the TV ads and the rest of it, and while I agree with the right to be able to have billboards and TV ads as lawyers, it has not helped our reputation as lawyers that we have those public communications. But if we can talk about how we have made our community and our country safer, and we should be talking about that, and it helps to raise the estimation of the role of lawyers in our society. So in every imaginable way, using civil litigation to effectuate safety remediation is a fantastic aspect of being a plaintiff's lawyer. May I add, for those of you who may become defense lawyers and even defend tort claims, this is something that you should be doing with your with your tort defendant clients, is having these conversations. In fact, you may have a better shot at effectuating the remedies than I might have as a plaintiff's lawyer, because presumably your client will inherently trust you since they hired you to defend them, whereas they might not be quite as receptive to me. And even beyond that, even if you don't practice in the tort field, you should be thinking about all of your representations, both from the standpoint of what you were hired for formally, but also more broadly, how you can advise your client, this could be criminal or civil, about how to improve their circumstance so that there's no repetition of what brought them to you. And I hope you'll think about that deeply. You know, you could be a public defender and you're hired to defend a person with respect to a charge, but you recognize an issue with your client, which you think can be addressed through perhaps mentoring or drug rehabilitation therapy or mental health counseling or vocational training or the like. Speak up. You know, you don't want to see that person again in the system. That's not good for anyone. And that's true of your DA as well. And so I think we lawyers need to think a bit more broadly about our role as counselor and our role in the community generally. And ultimately, those are the things that really stick to your ribs as a lawyer. The money that you make in the practice of law, whether it's great or small, it trust me, it diminishes in importance as you progress in your practice. And what really matters ultimately to you and your feeling about your role as a professional is how you've made other people's lives better and how you've made your community safer. And every representation that you have, there's an opportunity to at least consider whether there's an aspect of that in that work you're doing for your client.
All right, I'll open it up to questions. Yeah.
Thank you so much for being here. You made reference to a couple of different kind of plaintiffs-oriented or antagonistic policies.
Yes.
Like policy changes. If you could change any particular policy, maybe let's say outside of just like decaps and things, but if you could really get creative with lawmaking, what would you do to make plaintiffs' practice better for everyone, but particularly for plaintiffs?
Well, we have to get rid of immunities and caps. They're a tremendous scourge on our society. In California, MICRA and the minuscule modifications of MICRA, if you don't mind that alliteration, it's a disgrace that people in California do not have access to the courts for medical malpractice. It's shocking. When I explain to my torts class the rules around MICRA, my students are shocked. In Pennsylvania, we don't have that problem, but we effectively can't sue the government in Pennsylvania for torts because we have a horrifically hard-capped system. And of course, we're not effectuating the deterrence function of tort by having caps and immunities, are we? So it's a very significant problem. Section 230 is a huge problem, and
Explain what that is.
Yeah, so Section 230 of the Communications Decency Act of 1996 provides an immunity for internet publishers in their role as publisher. So the most scurrilous, defamatory, horrific statement that could be made by any of us about someone else on Instagram today, right now. In fact, it's happening as we're sitting here. I think we all know that, right? Well, the person who posts it, the writer of the defamation, could be sued, but they're usually judgment-proof. And Meta, in that situation, is acting as publisher. And if you were to do that, not through Meta, but let's say through the newspaper, you know, the Chronicle in San Francisco or the New York Times, well, the Chronicle in San Francisco, the New York Times would be subject to liability for defamation, but Meta is not subject to liability for defamation because the Congress, in their unwisdom, gave the nascent internet industry this immunity, thinking it would spark innovation, and that people would not invent things like Facebook if they didn't have immunity, which obviously was a terrible mistake. And we cannot get rid, I tried very hard, I'm still trying, I cannot seem to get rid of Section 230. By the way, Section 230, that immunity, it only exists in the United States, Canada, and New Mexico, and that's by virtue of NAFTA. Every other country in the world does not permit immunity for the internet companies. And there are sensible compromise positions with respect to that. So, for example, I have proposed, and this was not something that I invented, but I proposed that Section 230 be modified so that if someone feels they've been defamed, they could notify the internet company. The company would have, let's say, 48 hours to take down the post, and if they did, they would continue to enjoy their immunity. And if they don't, then they would be treated like all other publishers and be subject to tort liability for defamation. And of course, they would still enjoy all of the protections that other publishers have. So it would put them in no worse position than the New York Times if they did not take down the post. And that is the law in many countries around the world. And it's worked well. That makes a lot of sense to me here. I mean, that would deal with Meta's objection, oh, we can't possibly moderate all posts, which I know is bullshit. I know this is a big film, but that's okay. I know that's not correct. I know that their AI programs can effectively moderate posts, that they don't need that kind of protection. But okay, let's say you do. We'll have a notice and take down provision. You get notified, you're then going to need to look at it, or not, within 48 hours. And if you don't take it down, you're going to be subject to liability. But again, can't seem to get that through. Once an immunity is passed by a legislative body, it's so hard to undo that. So I think that's the biggest problem, is caps and immunities. Sure.
Yeah.
Do you see third-party litigation funding as kind of like a way to just increase democratized access to justice, or are there concerns around it sacrificing the non-pecuniary goals of court law, make it sort of bad on balance? How do you think about the whole ecosystem?
Yeah, so you're asking about third-party litigation funding, and I would have to ask for some clarification about what kind of third-party litigation funding we're talking about. So the one aspect that I'm in favor of and I utilize is so-called pre-settlement financing, which is where I'll have a client that has very significant ongoing needs that they can't afford to pay until their tort claim is resolved. Let's say, for example, medical care, or to modify their home because they're handicapped, or perhaps a wheelchair accessible van, or maybe a ramp coming up to their house for their wheelchair, that kind of thing. They may need $20,000 or $50,000 or $100,000 while their case is pending, and I'm not allowed to loan them money under the ethical rules, but other people could, and I'm in favor of that because it takes pressure off them during the course of the case. They're not then in a position where they feel like they have to compromise their case quickly for an inadequate amount of money, and that also takes pressure off me because they're not pushing me to effectuate a quick and inadequate settlement. So it tends to level the playing field between my client and the defendant. And those loans are secured only by the litigation itself. So I'm not guaranteeing those loans, nor is the client guaranteeing the repayment of the loans, except through the proceeds of the litigation, if any. So I like that. I'm in favor of that. If you're talking about hedge funds and the like, who are, I'm seeing a nod, Hedge funds and the like who are funding law firms, paying for the law firms, advertising, paying for the law firms, case costs, paying for the law firms to run during the pendency of, let's say, of a mass tort and the like. It's okay with me. This is America still, mostly, and it's the free enterprise system, and I think people should be able to contract to borrow money from a hedge fund to run their law practice. And if the hedge fund wants to fund a law practice, I think that that's okay. I don't choose to do it because I don't need to. Just being straight up with you about it. I don't need to ask somebody else for money to fund my law practice. And I confess, I really would not want to be in that position where I would have those conversations, because I'd be concerned that it could veer into me feeling pressured perhaps to resolve litigation that's been funded by somebody else, and I certainly can't delegate to anyone except my client the decision about whether to resolve litigation. And I'll be damned if I'm going to let a third-party financier tell me whether to resolve a case. And of course, they really can't do that, but pressures can be subtle in these matters. So I think it's okay that they exist. I think it'd be better for lawyers such as our firm not to use them. But I do see the potential for abuse. Now, I know that corporate defendants find the hedge fund investments in plaintiffs' firms to be horrific, and the reason for that is because that further levels the playing field, doesn't it? It creates more advertising for cases, and therefore more cases. It does fund a lot of law firms and their litigation that couldn't otherwise get into, let's say, the mass tort world. And so corporations have been trying to shut that down in a variety of ways, and one of which is public disclosure of law firms that are borrowing money from hedge funds to litigate cases. I'm dead set against that. Excuse me, but last time I checked, I'm not allowed to know how much a defendant is paying its lawyers and the like. It's none of my business, and it's none of corporate America's business how plaintiffs' lawyers run their law practices. So I'm offended by that concept, but we are dealing with rules proposals in various places seeking to let defendants into the inner workings of plaintiffs' firms, and I think that should not occur.
I want to ask one follow-up about that, which is, beginning when we're talking about pre-settlement financing, you pointed out that under Rule 1.8E, lawyers are not allowed to advance living expenses to their clients. Lawyers can advance case expenses, but there's this sharp line between case expenses and living expenses. If you had a eraser, would you erase 1.8E, or are you glad for the protections that it affords?
I think 1.8E makes sense, but I think it should be clear in every state that it's okay for a lawyer to give their client money. The reason why we're not supposed to loan our client money is because then we have the outline of a potential of a conflict of interest, because we want to get repaid our loan, and it's possible that that loan could be so substantial, at least in our way of thinking, that it could interfere with our judgment about whether our client's case should be settled or tried. I see the logic of that, although it kind of runs against the grain of the fact that since we work on a contingency fee and we don't get paid unless our case is successful, we have that conflict also anyway in our relationship. So I'm not entirely convinced that the bar on loaning money to clients is consistent with the structure of our fee system. But I understand it at least. But what I think is absolutely fine but rarely done.
And illegal. I mean, you can't give under Rule 1.8E to your own client.
Okay, well, may I say that I would defer, I would defer to you, Nora, in absolutely anything in which you assert that you know the answer. But I have looked at this in Pennsylvania, and I am satisfied that in Pennsylvania we are allowed to give our clients money. I have not done it, but I do believe we are allowed to do it. I believe we're allowed to make a gift to our clients in Pennsylvania. I know I'm being looked at like I need remediation. I need remediation.
You might want to seek ethics counsel before you.
May I say as a very young lawyer, when I was working for James E. Beasley, who was the finest plaintiffs lawyer in Pennsylvania in the second half of the 20th century, and who gave the naming gift to Temple University's law school. When I was a very young lawyer, I had a case where a client needed a medical test. I recall it costing $500. I knew the rules around loaning money. I knew I couldn't loan money. I thought this was above my pay grade. I went to my boss, Jim Beasley, and I said, Jim, here's the issue. What do you want to do? And he said, tell the bookkeeper to write the client a check for $500. And I went back and looked at the rules. I wasn't satisfied that was ethical. I was satisfied that it wasn't my call. And I went back to my boss and I said, Jim, I don't know that that's ethical under the rules. And I talked with him about the issue of loaning money. And he answered in a manner that was expletive-laden. But it boiled down to, here's what it boiled down to for him. It boiled down to, let somebody make a charge against me. And I really understood that. I'm not saying I would have done the same thing, but I really understood that. His viewpoint was, the client needs a medical test. They have a medical problem, they need a test, they need $500, they don't have it. Of course, I'm going to give them the money. I don't believe I'm barred from doing it. Jim Beasley was a very ethical person. He didn't believe he was barred. I wasn't convinced he was right or wrong. I thought it was unclear. I later looked at it more carefully. I came to the view that I had at least until now. I thought he was equitably right.
Mm-hmm. Oh, I agree. I mean, so I think this is one of these places, and I think it's really useful for law students to see. I hope that the students in the room who have had ethics with me see this already, which is this interesting line between what is moral and what is ethical under the rules. And I think this scenario you're laying out, in most states, giving the $500 would be a clear violation of 1.8E. Now, I cannot swear to Pennsylvania in particular. There could be some nuance I do not see. But I view this as a place where, as a lawyer, can be really hard that the rules put you in boxes to do things that are really contrary to your own moral commitments, and how to navigate that space.
Yeah, and everybody at this law school should take Nora's class on called the Plaintiffs Lawyer Professional Ethics. It's a fantastic class. The mass tort practice is a constant conundrum for me. I find myself feeling the need to take a shower frequently in the mass tort practice. Nora and I have had many conversations about aspects in the mass tort practice. And Nora one day, I think trying to make me feel better, said to me something like, and you'll remember this better than I can perhaps, but something like, Shanin, the rules were written in a way that make it impossible for you to practice law. Just something like that.
Yeah.
And it made me feel better. Because it made me feel that as long as I did my best, that under her saintly disposition, I was absolved of my sins, and that gave me a little bit of comfort. But I see practices in the mass tort field that constantly outrage me. May I mention one aspect?
Yeah.
Why is it? Why is it, guys, that if I have a class action case involving this pen, which leaks, and the loss to each person that buys the pen is $1, that I can't get the class action case settled unless a federal judge says that the settlement for the class is fair and reasonable, and the judge in that role is a fiduciary to the class. The case law is clear on that. The judge has a fiduciary responsibility to the class to be sure the class is treated properly. Right? You guys learned that in civil procedure and/or federal courts at this law school. I agree with that rule. I hope you do too. A lawyer can settle a mass tort claim for 100, 1,000, 10,000 clients, and they don't have to get approval of that by a federal judge. Why? And it doesn't involve a pen and $1. It involves a wrongful injury, which is obviously much more serious to many, many people. Of course they should have to have somebody looking over their shoulder to be sure that they're not conspiring with the defendant to settle the litigation for the smallest amount that the small c class will accept in resolution of these claims. Because after all, the truth of the matter is that if a case is settled for $10,000 and worth $100,000, if it were settled properly, if the plaintiff's lawyer is going to make $3,000 as a fee on a $10,000 settlement, that's not a lot of money. And even $30,000 on $100,000 is not a lot of money. But if the lawyer has 100 cases or 1,000 cases and settle the cases for inadequate sums, a small amount of money, a small fee multiplied by a large number is a very large number. So when a lawyer can settle mass tort cases for inadequate sums, we have two winners there. We have the defendant is a winner because they get releases for way less than they should be paying for releases, and the plaintiff's lawyer is a winner because he's made a small amount of money on one case multiplied by his number of cases. And then every one of his clients, it could be 100, it could be 1,000, they're all losers. And I'm sorry to say this, I don't trust my colleagues in these situations. They should have to get judicial approval for that. I have proposed that. You know how much support I've gotten for that? Zero. You know who's against it? It's only a small group of people. Here's who's against it. The plaintiff's bar, because they don't want people looking over their shoulders. The defense bar, because they don't want their clients to not be able to effectuate settlements for small amounts of money. Defendants, because they want to be able to effectuate settlements for small amounts of money. And federal judges, who don't want the work and who don't want to have to deal with the issue of not approving mass tort settlements, because in those cases stay on their dockets. So everyone in the system is against that basic proposal. Ouch. That's the kind of thing that makes me want to take a shower.
All right, last question.
I'm interested in your opposition to anti-SLAPP laws. I've generally heard them sort of proposed because they're supporting the speech of people who might not have the resources to be litigated against by people who like to sue for defamation all the time. I'm wondering if you think sort of the policy implications are outweighed by being the plaintiffs, on the plaintiff side, or it's more about the equities of.
Every state in some form has adequate protections for defendants in civil litigation who've been wrongfully sued. Rule 11 in the federal courts, and every state has their own either common law or statute or some combination of both, or for that matter, rule of civil procedure that provides for fee shifting when claims are brought or maintained without reasonable basis. We don't need any more protections in our society in that regard. And why should a person who is speaking on a matter of public concern have any greater protection in that regard than a physician who's wrongfully sued or a motorist or a product manufacturer? We don't need or should have two sets of protections for people wrongfully sued.
All right, that will be the last word. Please join me in thanking Shanin.